I have been excited about this segment for a long time. Have I not? I've
You've
been telling you for a while.
You've been talking about it for a while.
It's all things self-defense and the Florida rule for stand your ground. I mean, people don't know. We do not know what this means. When can you protect your house? When can you protect yourself if someone's attacking you? Who else would I ask than our great friends from the Joshi law firm? Rajan Joshi is here.
Thank you.
And for the first time, Muna Abraham. Hello, guys. How are you?
Thank you. Good.
Let's start generally with self-defense. I mean, a lot of people kind of understand what that means. If someone punches you, maybe you punch back. But what does self-defense mean generally?
Well, in Florida, Florida has some of the most liberal self-defense laws in the country. Basically, you can use force, justified force, either non-deadly force or deadly force if somebody's coming and attacking you. In Florida, you don't have to retreat. Some states you have to do everything possible to get out of the situation, and only then can you use self-defense. And basically, the law is that if you're in reasonable fear of bodily harm and you feel threatened, that you can use force on force.
But let me tell you something, and I think this is very important for you to know. If this comes up in your life, if the police, the detective is asking you questions about it really comes down to what you tell them at the time. And words can be used against you later. If anyone is asking you right now about whether, did they hit you first? Did they have a gun? You do not need to answer these questions on your own. You need to call the Joshi Law Firm first. It's a free consultation, all right, before you talk to anyone about this, because the words you use when you feel like everyone's your buddy right there, but these words can be used against you later. Trust me, we've seen it a million times. Isn't that right?
Absolutely. I've had cases, murder cases, where, the client explains in detail what happened. And of course, there's excitement, there's adrenaline, there's fear going on, shock. And then the detectives will sit there and question them a few days later, a week later, and then they'll be like, it was inconsistent. He said the person was, 60 feet. Now he's saying they were 45 feet. And all of a sudden they're charged with murder based on little factors. And a lot of times the detectives have made up their conclusion and they're just trying to find evidence to support it. And that's why it's very important never to talk, get a lawyer, get your story, correct, and present it. Present it correctly. Otherwise, they're going to just tear apart. And no one's consistent all the time, even if they're telling the truth.
That's right.
Yeah.
Exactly.
Someone told me once that you're supposed to just repeatedly say, "I was in fear for my life."
Well, the proper thing to do is to ask for a lawyer. The more you talk to the police, the more they're going to dissect what you're saying, and you may trip up on what you say, and then they're going to get you over there. And being in fear of your life is not in and of itself a justification. Like in self-defense, suppose somebody's coming at me with a knife and I hit them with a baseball bat. They fall down, knife falls down, and I go over there and I say, well, you should never do that again. Bang, right there. I'm no longer justified in that second smackdown.
It's just the old adage, you need to ask for a lawyer, you need to call your lawyer, and before you talk, you just do. They understand that. I mean, the cops aren't going to get mad at you for saying you need a lawyer. It's your right.
And, in most situations, the jury will never hear about it.
That's right.
A person is exercising their fundamental Fifth Amendment right to remain silent, not to incriminate themselves. And when they start reading you those rights, everything you say can and will be used against you. That means it will be used against
exactly.
you. Do not talk.
Don't talk. I totally agree. Muna, welcome to the show. First of all, glad to have you here. Stand your ground, certainly a hot button topic around this state for a few years now. What exactly does that mean, stand your ground?
Absolutely. Thank you for having me.
Of course.
In Florida, it means that you do have a right to defend yourself or to stand your ground. And that doesn't just cover, your criminal case. It could also cover some civil liability. It can be used even before your trial, before you have that self-defense argument at your trial. You could have a hearing, and that is when you could argue for the first time that your stand your ground motion, and if it goes well and the judge rules in your favor, that could mean that you get released from jail. And so it's also protecting you from incarceration.
And what it is, basically, it's, you ask the judge ahead of the trial to dismiss your case altogether on, self-defense. And it's a lower standard, to prove a case beyond the reasonable doubt the state has beyond a reasonable doubt. We just have to prove clear and convincing evidence. And let's just say the judge says, no, too bad, I'm denying the motion. Then you get another chance at trial. So, it's two bites at the apple. So Florida has some of the best self-defense laws possible. And the one thing I love about self-defense is you can attack that victim, and what your client knows about the victim is a free-for-all. If his violent past, the threats he made, usually in a criminal trial or in a trial in general, character evidence of the victim is limited, and you can't bring out, things about the victim except in certain situations. In Florida, under self-defense, if you can bring out whatever you know that could lead you to believe that person was acting violent or was a threat.
So what does this mean for the homeowner? Let's take it from the homeowner perspective. I'm in my house and someone knocks on my door and they have a gun or they're saying threatening things to me. When can I use stand my ground in my
Hang on, they're
defense?
knocking on your door?
Yeah, I guess. I don't know.
Or they
In
came
Florida,
through the door?
There is a presumption that if somebody's unlawfully entering your house, that they're entering to commit a great bodily harm to you. So you are justified in using self-defense. It's a presumption. So, if some, teenage kid is breaking in with a case of beer to see, your son, doesn't mean you can just shoot him. So it depends. If somebody's coming into there, breaking into your windows, coming in there, and the threat is reasonable, there is a presumption that they're coming in to commit, death or great bodily harm. And at that point, the law does justify self-defense.
What if they're coming in to break into your house, but then they're running out of your house? Is that? I'm not trying to get too specific. I'm just trying to make sure that we understand it.
The threat must be immediate and imminent.
Okay.
So when the threat, it's kind of like the baseball bat situation. If the person breaks away from the threat, and you go running around like the Old West and start shooting them, at that point you have crossed the threshold of the protection of self-defense, and now you're getting into criminal liability.
I was at a gas station the other day pumping gas. I got back in the car, rolled the window up, and someone was kind of banging on the window. And I was scared. I mean, can sometimes this self-defense go to just not in your house, but in your car?
Absolutely. If somebody's unlawfully breaking into your car or your house, that presumption applies to the car as well. Or if they're trying to get you out, or they do manage to get you out of it, that presumption then applies as well. But again, it's a presumption. So, if somebody's breaking into the back window of your car and reaching in to grab, change, and you turn around and you shoot them, you may have to answer for that.
Right. What if I'm in the house and I hear something outside and someone's breaking in my car outside, but I'm inside the house?
At that point, no.
Okay.
At that point, the defense doesn't go towards property. It does go towards other people. If somebody's coming at and like attacking her, you are justified in defense of others as well. Property's not so much unless you're within the property and you are feeling threatened.
Interesting stuff. How do you think our laws here compare to other states? I mean, are we a little bit liberal? Are we more allowing of self-defense here than other states?
Absolutely. In other states, they have the duty to retreat, and Florida used to require that. But then Florida said, no, that's asking too much. If somebody's running at me, I don't have to run away and try and protect myself every which way possible before defending myself. I have a right to stand my ground and meet force with force. If I feel threatened, as long as I'm legally in the area that I'm at.
Now, let's say someone is breaking into my house, but they don't have a knife, they don't have a weapon, they don't have brass knuckles. Does that change anything? I mean, I'm still scared. Someone's breaking into my house.
Presumption applies.
Yeah.
The presumption applies, but those are factors that can be used against you if the state decides to prosecute. So it has to be a judgment call, because the presumption can be overcome with the state's evidence. If they can prove beyond a reasonable doubt that this person was not going to create any threat or great bodily harm, then that presumption doesn't apply.
Yeah, I mean, I think the key is, it becomes very technical at this point with this stand your ground. I love the fact that you get 2 bites of the apple, meaning you can ask the judge to dismiss the case, then you ask the jury to acquit you. It's 2 bites at the proverbial apple, but it really comes down to these communications early on with the detectives or the police on the scene. And that's why I'm telling you, whether it is a stand your ground, a self-defense issue, or any criminal issue, every time, look, we all love police, and we need police. We love detectives. We love what they do. We really do. But anytime that they're calling you, asking questions, they're going to act like you're a witness. They're going to act like you're their buddy. But at the end of the day, they're trying to figure out, okay, who committed this crime? And they have a lot of cases going on. They have a lot of cases. They want to solve these crimes, and once they have in their head that you did it, they're going to charge you. And that's why if you are charged with a crime or the police or detectives are calling you, my advice is that you don't really want to talk to them. You want to call the Joshi Law Firm first. The phone number is right on the screen, 321-282-1055. Literally, they're standing by right now. You can call them right now. We will connect you with them immediately. Great job as always.
Thank you. Thank you for having us.
Muna, thanks for coming in. Great to
thank
meet you. And hope to see you guys next week here
Thank
for
you.
some more interesting stuff.